Ito ang Bombo Radio Philippines. Fully digitalized. Numero 1 sa balita, komentaryo, drama at serbisyo publiko. Bombo Radio Philippines. Bombo Radio Philippines. Unmatched. Number 1 and most trusted source of news and information.
Radio Bombo!
Mga kabombo, mga Kastar Nation, tayo ay nagpapatuloy dito sa ating special coverage kaugnay pa rin ng mga kaganapan dyan sa International Criminal Court. At sa puntong ito, oras natin mga kabombo at mga Kastar Nation, ganap na hong 7 minuto makalipas ang ikapito ng gabi. Kunin natin muli ang linya mula ho dyan sa The Hague sa Netherlands upang masulyapan muli natin ang mga kaganapan.
He spoke at length in the beginning about Article 7.1 and an alleged problem or inconsistency with the history case in our definition of the civilian population in this case. The law is very clear. All that Article 7.1 requires is that an attack is directed against any civilian population. That term, any civilian population in 7.1, is not limited to populations defined by nationality, ethnicity, or another distinguishing feature of that nature. It's a question of fact to be decided by the trial chamber. We have set this out, paragraphs 17 through 20 of our DCC. It is not particularly complicated. It is not blurry or ambiguous. We stated that alleged criminals in the Philippines are the civilian population, which are the object of the attack. That's a factual issue. So the position taken in the El History case, which is different, obviously completely, factually to this case, is irrelevant. Second, the issue in El History did not concern the definition of the civilian population. It was about the nexus requirement, under Article 7, and whether it is necessary for victims of the underlying acts or crimes against humanity themselves to be members of the population. It was a different issue completely. And we have defined the population in this case. That just reminds me of what he said today at one point. Oh, well, these victims weren't necessarily related to drugs or the war on drugs. Read our brief. Read the DCC. It makes it clear that it's criminals, including drug dealers, drug pushers, drug users. The incident I went through, incident 3, in my presentation on Monday, I made it clear the victims there in Davao were alleged thieves. That is why they were murdered by Mr. Duterte. Very quickly, he complained or spoke about well, no, I'm going to skip that, Your Honor. It's not important. Moving on, he also made yesterday multiple comments that were inaccurate about the common plan alleged in the case. First, he said there was no direct evidence that even 2 of the co-perpetrators met in person to discuss the plan, the common plan. Legally, there's no requirement that they do so. However, factually, what he stated was incorrect. We have brought evidence of such meetings, and they're in our pre-confirmation brief. I won't go through it, but if you look at paragraph 27 and the items cited in footnote 135 of that paragraph, it sets it out. I'll come back now to the meaning of the term neutralize in the context of this case. it's open to interpretation in the abstract. But my friend, in trying to persuade your honors to take the view that neutralize didn't mean anything nefarious, quoted statement from Chief Ronald Bato de la Rosa, co-perpetrator de la Rosa, that neutralize did not mean to kill. That was at T006, page 31, lines 2 to 11. So it's been criticizing the credibility of our witnesses. Cites the police chief to say, the police chief who signed CMC 16, to say that neutralize is a neutral term that shouldn't be taken as showing any criminal intent. But we set out in our brief multiple witnesses for the mayoral period and for the presidential period who will testify that to neutralize means to kill. That's again set out in the brief, paragraphs 6 and 24. I'll read out just one example. This is ERN PHL OTP 000-15390-R01 at 0011, lines 345 to 346. Question of this insider witness. Okay, and the words eliminate and neutralize, what do they mean? Witness's answer, kill. You have to kill, whether it is a legitimate operation or not a police operation. So all of the dancing around about the term neutralize doesn't rise to the level where we would not be meeting our standard for confirmation today. One more example, my friend talked about it today. This is incident 13, in which the murder victims were Mayor Espinosa and Raul Yap. As we showed on Tuesday, Mr. Duterte, I won't play the video again, identified Espinosa as involved in drugs and said that he should be shot on sight and tracked down like a dog. And Mr. Kaufman said, yes, but Mr. Espinosa surrendered. And then tried to portray the murder of Espinosa in a jail cell as legitimate self-defense. In a jail cell, there's a shootout. The telling point here, as we said on Tuesday, transcript 5, page 10, lines 9 to 10, in the PRRD list, it was brought up, I believe, in the presentation. These two victims of incident 13, they are noted as neutralized on the list, not on the day they are arrested, not on the day they go to jail. They're marked neutralized on the days they're killed. So they were neutralized at the time they were murdered, per Mr. Duterte's government at that time. As I said in my submissions on Monday, right from the beginning, we acknowledge throughout his speeches, Mr. Duterte and some of his co-perpetrators, I used the term allies on Monday, referred to shoot to kill and self-defense, and that they sprinkled in these references to due process and legality. The evidence shows, as I said, that was only to build a veneer of legality, to create an impression of legality, and to give his lawyers something to say when this day came. And that's exactly what has happened. Mr. Kaufman has gone through, repeated these, when he can, as some kind of mantra that supposedly exculpates his client. Does not. As I said, this is the lawyer, Duterte, trying to build in a defense in case he was ever held to account for his crimes. The facts can't be denied by these sprinklings. He ran a death squad in Davao that he created. He ran it for over 20 years before he became president. His promise was to kill thousands, and he did. So it doesn't matter how many times he tried to throw in a caveat. And again, as I said, this is not uncommon in crimes committed by powerful figures. They try to build in a defense. One point Mr. Kaufman made yesterday, again, showing why this case is ready to go to trial and should not be dismissed. He refers to witnesses providing what he says is exculpatory evidence. He misstated these witnesses by saying they were OTP witnesses. They're not. We're not relying on them, but their statements are disclosed. We found these witnesses and interviewed them through the process that he portrays as somehow corrupt or biased or I don't know what. They provided exculpatory information, and we disclosed it. And that is somehow meant to say that this case should not go to confirmation? I mean, these witnesses are interviewed under 55-2. They're as suspects. Is it really unusual that when you're interviewing somebody who was involved in the crimes, that they say, I didn't do it? Does that mean that this case should not go to trial? Again, we go to trial. He can call those witnesses. The trial judges will listen to his witnesses, listen to the OTP witnesses, and then decide if we've proven our case beyond reasonable doubt or not. I'll speed up a bit, Your Honors, because I don't want to go over my time. He made a small point I just have to respond to, making a call. Why aren't there more investigations? Why aren't crimes being investigated now in the Philippines? Well, his client prevented all that by withdrawing the Philippines from the Rome Statute when he thought he might be prosecuted, thereby ensuring that we would not have jurisdiction after a certain period. Another point. My friend is trying to kind of have it both ways on how Your Honor should treat Mr. Duterte's utterances, his speeches, his words. On day 1, T0004 at page 30, lines 18 to 19, my friend said, Duterte's word was his word and the people knew it, end quote. Yesterday, worried about his client's confessions, that's what they are, he said, quote, this is at T0006, page 7, lines 5 to 7, he said, quote, one cannot rely on anything coming out of Mr. Duterte's mouth. All right, that's good to know if he ever decides to testify. And for his representations on interim release, that you can't trust a word that comes out of his mouth. But beyond that, as I went through on Monday, 3 times under oath, Mr. Duterte said in committee hearings, I have a death squad. Is Mr. Kaufman saying that his client is a liar and a perjurer who has no problem lying under oath? Limited use statements. I won't go through all the, frankly, nonsense that we heard about limited use statements. What I want to make clear, he tried to create an impression which is just not true. Not one witness has been granted immunity in this case. None. There is no such thing as virtual immunity or whatever he called it. He said something similar today. It's standard practice to use these statements when interviewing suspects under 55-2 who have rights, and they do not grant immunity. It just means a statement can't be used against that particular witness. And if they lie during those statements to us, to the OTP, then the agreement is void and they can be prosecuted. And his suggestion somehow that we should not interview the direct killers, Mr. Duterte's killers at the bottom of the pyramid, they shouldn't be interviewed, that's clinically insane from a prosecution point of view. And of course, some of those persons will get limited use statements if their lawyers request them. And finally, we're here in this court to prosecute the most responsible, and the most responsible is his client, former President Duterte, not the people on the ground who committed the killings. They are responsible, but they are not the most responsible. And unlike his client, the ones who have come forward have shown remorse for what they have done. His client, contrary to everything he said in the last few days, the last 3.5 hours, repeatedly admitted committing the crimes we're here for. His killings of his own people, the Filipino people. We saw some of those in our presentations. I'm sorry, I missed one point. He said there was no linkage of the incidents to Mr. Duterte. He said, my friend, not one incident where the direct order came from Mr. Duterte for one of these incidents. Well, he should look at incident 1 of the ones we have charged. And I'm afraid I don't have my site because I skipped around. But in that incident, the evidence shows that we have a witness who heard Mr. Duterte on the phone, who heard that the order came from Superman, his client's code name and nickname. Mr. Jeremy is helping me. It's at para 89 of our brief, Your Honors. So that was wrong. That is, I just wanted to reply. He said that several times. It's not true. Back to Mr. Duterte. He's proud of his killings. He wants to be remembered for them. Decades of murdering his own people, murdering the children of the Philippines. And he claims that he did it all for his country. He doesn't deny it. He says, as I said early on, it's a necessary evil. It's for the greater good. Doesn't matter how many kids I have to kill. I'll clean up the Philippines. Now, I want to play a clip, Your Honors, if we can do that, James. This is, you'll see the beginning. I played just a few seconds of it. I'm going to play more of it now, about 2.5 minutes.
Na ginawa ko man ang lahat sa panahon ko para may konting katahimikan at mapayapa ang buhay ng Pilipino. Ang problema nito, ewan ko kung ang tingin ng ako'y raw yung o ganito na lang. Ito ganito na lang. O sabi ko, assuming na totoo, totoo talaga yung naririnig ninyo. Bakit ko ginawa yan? Para sa sarili ko? Para sa pamilya ko? Para sa inyo at ang inyong mga anak sa ating bayan. Ang higiin ko na lang sa inyo, total, kung ganito man talaga ang swerte ko sa buhay, okay lang, tatanggapin ko yan. Eh, wala tayong magawa.
Excuse me, Counsel, you have 5 minutes left.
Hulihin tayo kung ikulong tayo. Kaya lang, in the meantime, mag-contribute kayo, baski $5, $10, para paglabas ko sa presuhan, paggawaan ninyo akong monumento katabi ni Rizal. Si Rizal may hawak na libro eh. Akin.
Okay, what did we see there? This is essentially Mr. Duterte's farewell speech. It was made on 9 March last year, 3 days before, as he says, he was apprehended. He was not going to surrender, apprehended and surrendered to The Hague. What did we see there? First, I won't repeat it, shows total, utter contempt for this court. Second, referring to, quote, his sin, end quote, he says, assuming that all the talk you hear is true, assuming it's all true, why did I do that? What is the talk that's all true? It's obvious. After he says that, he says, problem is, they think I'm the one who, and the crowd cheers. Again, he doesn't say it out loud because he knows he's on video. He doesn't want the words there. Assuming I'm the one who killed all these people. So he makes a little motion. Crowd goes wild, and he smiles because he likes that after he's made that statement. What innocent person has ever said, assuming I committed all these murders, it was for a really good reason? That's what they would like you to believe, that he doesn't mean it. And he says he did it not for himself, not for his family, but for the Filipino people, and it's obvious what he's talking about. He's talking about the murders. Again, the ends justify the means. Again, for him, the murders are a necessary evil for the greater good, as we heard right at the beginning of his career when he's teaching police officers to plant evidence. The end of that video, what does he ask for? He says, I might go to jail, what can we do? But when I get out, contribute money so there can be a monument erected of him when he's released from jail. And he describes what he wants that monument to be to himself, former President Duterte. A statue, not holding a book like the national hero Jose Rizal, but holding a gun. 3 days before his transfer to The Hague, this old man, you could see it still up there. What does he want to be remembered as? The man with the gun. And he's just taken credit for killing his own people. It's time for him to take responsibility for these crimes he brags about and glories in. Can we go to the next one quickly? I think I got about 3 minutes. James. This is tab 146.2. It's a quote from a speech on August 16th, 2017. What did he say? Quote, I know I will have my own downfall. I cannot be president forever. I know that they will demand to answer for all this dead. End quote. And he was right when he spoke those words. He must answer for the dead. The victims demand it, justice demands it, and for purposes of confirmation, the evidence demands it. We have proven it to the level for this to be bound over for trial. We ask you to do that, Your Honors. Thank you.
Merci beaucoup, Monsieur Nick.
Thank you very much, Mr. Nichols. We will now go to the closing statements of the common legal representatives of victims. You have up to 12:30. Maître Andres will present the closing statements. George Motok, you have the floor, Mr. Andres.
Your Honors, good noon. In our closing statement, the common legal representative for victims will first rebut the defense submissions. Then we will provide the larger context why the confirmation of the charges against Mr. Rodrigo Duterte is vital for the victims, especially in relation to their communities and the Filipino nation. Your Honors, listening to the defense submissions on the merits yesterday and today was to me like listening to the parable of the elephant, wherein they want us to see only the parts of the elephant: the trunk, the tusk, the ears, the head, but not the whole of the elephant. We must look at the whole context. Madam President and Your Honors, it's also my duty as the common legal representative for victims to express the views and concerns of the victims. As they're watching these proceedings, they have stated, and when they heard the defense effectively submitting that the chamber should ignore the systematicity and the widespread nature of the attack, it's like their murdered loved ones are being murdered again. Having conveyed that as my duty, we will address the defense submissions in seriatim with 10 rebuttals. First, on Mr. Rodrigo Duterte's speech, defense argued yesterday that, and I quote, relying on the former president's speeches as a means of proving criminal intent is impossible. I am quoting the transcript of yesterday at page 4, lines 5 to 6. But the victims convey that the Philippine context is vital in knowing and understanding the criminal intent and impact of Mr. Duterte's speeches. Under the Philippine Constitution, the executive power shall be vested in the President of the Philippines. Whatever the President publicly states is policy. And in the Philippine cultural context, when there is strong respect for those in government positions, especially the President, as head of state and as head of government, the words of the President is to be obeyed, no matter what. Especially for Mr. Duterte. He has portrayed himself as a man of his word. The defense even emphasized, and the prosecution also referred to this last Monday, that, and I quote the defense, for President Rudy, his word was his word, and the people knew it. End of quote. And that's the transcript of Monday, page 30, lines 18 to 19. The defense even stated that, and I quote, Rodrigo Duterte was and will always remain a unique phenomenon. End of quote. Referring to the transcript last Monday at page 30, line 14. Mr. Duterte was and is indeed a unique phenomenon in the public and vulgar way in which he used his words to dehumanize the victims of his anti-drug campaign, to excuse their murder, to shape the Filipino psyche to his murderous rhetoric, and to predispose the government agencies under his presidency to follow his words as presidential policy and as orders. And the records show that every time Mr. Duterte exhorts the killing, the murders of alleged drug users, people are murdered all over the Philippines. To our second rebuttal, we rebut the defense legal theory in its Thursday submissions vis-a-vis count 1, which contains 9 incidents of murder during the mayoral period of the suspect. The defense argues concerning count 1 that this is allegedly, and I quote, hardly widespread. And I'm quoting the transcript of 26 February 2026 at page 6, line 23. We strongly disagree. Widespread refers to the scale of the attack. Courts and commentators interpret it through several indicators, such as the large number of victims, the killings, the deportations, rapes, or other acts affecting many people. Geographical spread, wherein the violence occurs across multiple towns, regions, or a broad area. The long duration, the sustained attacks over time rather than isolated incidents. The mass impact on the civilian population. The attack affects the population as a whole, not just a few individuals. The focus is on the quantitative magnitude. The attack is large in scope or effect. Systematic, on the other hand, refers to the organized nature of the attack. It is about how the violence is carried out, where there is pattern or methodical plan, repeated similar acts showing coordination, organizational policy or approval, wherein there's the involvement of the state or organizational structures, use of resources, logistics, weapons, or personnel deployed in an organized way. Regularity in pattern, not random or spontaneous, but structured. This is a qualitative criterion. The attack is carried out according to a plan, policy, or organized pattern. In the Nataganda case, the trial chamber has held in 2019 that, and I quote, the assessment of whether the attack is widespread is neither exclusively quantitative nor geographical, but must be carried out on the basis of all the relevant facts of the case. End of quote. In fact, in Nataganda, the trial chamber once again emphasized that, and I quote, the term systematic reflects the organized nature of the acts of violence and the improbability of their random occurrence. It refers to the existence of patterns of crimes evidenced by non-accidental repetition of similar conduct on a regular basis. End of quote. In reviewing the evidence in the record of this case, the only reasonable conclusion is that the attack against the specific group within the civilian population, individuals perceived as linked to drug crimes, was widespread and systematic. Contrary to the statistics shown by the defense, there is ample evidence about the high number of murders in this case. Third, on the death rate. Based on the 2019 trial chamber judgment on Nataganda, there is no requisite death rate in order to prove crimes against humanity for murder. Fourth, we rebut the defense legal theory in its Thursday submissions, which refer to the chapeau elements of Article 7 of the statute. The defense argues, inter alia, that allegedly, and I quote, this policy did not and could not constitute an attack directed against a clearly definable civilian population. End of quote. And I'm referring to the transcript of yesterday at page 10, lines 16 to 17. We disagree. Since the chapeau elements of Article 7 of the statute provides for, and I quote, widespread or systematic attack directed against any civilian population. End of quote. As the element of crimes provide, and I quote, attack directed against a civilian population in this context, elements is understood to mean a course of conduct involving the multiple commission of acts referred to in Article 7, Paragraph 1 of the statute against any civilian population, pursuant to or in furtherance of a state or organizational policy to commit such attack. End of quote. It is also essential to note that on the targeting of a specific category of civilian population, the pretrial chamber has held in the situation in the Republic of Kenya that, and I quote, the chamber takes into account the information relevant to the status of the victims, their ethnic or political affiliation, as well as the methods used during the attacks. End of quote. The same pretrial chamber in the situation in the Republic of Kenya further held that, and I quote, the issue of whether an act was committed as part of a widespread or systematic attack needs to be analyzed on a case-by-case basis with regard to each particular act. End of quote. Applying this legal principle to the case at hand, we have argued that the evidence on the record unequivocally shows individuals targeted by Mr. Duterte's anti-drug campaign overwhelmingly came from impoverished communities where social mobility is limited and opportunities are scarce. The same type of people in the same type of communities using the same modus operandi were targeted by Mr. Duterte's anti-drug campaign. People from the vulnerable communities, the poor and marginalized, especially in urban, informal settlements marked by high levels of poverty. Thus, we have shown last Tuesday, Your Honors, that Mr. Duterte's anti-drug campaign was really a war against the poor. Consequently, the document containing the charges was not, and I quote, muddled, end of quote, as argued by the defense in the transcript of yesterday at page 8, line 8. Rather, consistent with the chapeau element under Article 7 of the statute, the DCC in paragraph 17 refers to the, and I quote, widespread and systematic attack against the civilian population in the Philippines, end of quote, referring to paragraph 17 in the DCC. While the DCC in paragraph 20 specifies that this attack was against, and I quote, alleged criminals in the Philippines who were perceived or alleged to be involved in drug-related, including production, sale, and use, and other crimes such as theft and murder, end of quote, referring to paragraph 20 of the DCC. The latter, in paragraph 20, is merely a subset of the former in paragraph 17 of the DCC. Again, this framing in paragraph 20 of the DCC is synonymous with the framing in the situation in the Republic of Kenya, wherein police violence targeted perceived gang members. Fifth, the defense yesterday referred to Philippine Supreme Court issuances. And I quote, the defense inter alia referred to, and I quote, Supreme Court of the Philippines in petitions challenging aspects of the anti-drug campaign, end of quote. Referring to transcript of yesterday at page 26, lines 10 to 11. Madam President, Your Honors, I and Attorney Buturian are familiar with these petitions referred to by the defense because we were actually the petitioners' counsels in those petitions. And we actually argued before the Philippine Supreme Court last 2017 on this issue. Nevertheless, the defense critiqued the prosecution's manner of using the quote, Duterte's administration's year-end report for 2017, referring to PHL OTP 0003-3355 or tab 139 for the defense. Specifically, the defense argued that vis-a-vis the, and I quote, deaths of 3,967 drug personalities, end of quote, that, and I quote, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, end of quote. And I'm referring to the transcript of yesterday at page 32, line 1. Nevertheless, Your Honor, the same Supreme Court decision or resolutions referenced by the defense has stated with respect to those 3,967 drug personalities who died in the anti-drug operations from July 1, 2016 to November 27, 2017, as indicative of the state policy of extrajudicial killings under the Duterte administration. As held by the Philippine Supreme Court in its notice of resolution dated April 3, 2018, which is PHL-OTP-003-3058, and which is tab 112 for the defense at pages 46. I quote the Philippine Supreme Court. Aside from the OSG's submissions in the present cases, we take judicial notice of the Duterte administration's 2017 year-end report, where deaths in cases related to illegal drugs and the internal cleansing conducted within the Philippine National Police are touted as accomplishments. And Your Honor, the next sentence is emphasized in the original resolution. The government's inclusion of these deaths among its other accomplishments may lead to the inference that these are state-sponsored killings. In the section Fighting Illegal Drugs and subsection Real Numbers, we find the following figures. And Your Honor, I will just quote the one that was in emphasis in the resolution. 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. As well as 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. 6. The defense referenced, again, the same Philippine Supreme Court resolution. But that same resolution held that nothing else to substantiate the OSG's claim of legitimate police operations. And I quote that specific portion in the Philippine Supreme Court's Notice of Resolution dated April 3, 2018, which is tab 112 for the defense at page 47. The Supreme Court held that, and I quote, apart from these numbers and their bare allegations, there is nothing else to substantiate the OSG's claim of legitimate police operations. The lack of any submission of the required information and documents leads this court to believe that there is no basis to the OSG's claim. It is Hornbook doctrine that bare allegations unsubstantiated by evidence are not equivalent to proof, i.e., mere allegations are not evidence. End of quote. 7th, Your Honor. Again, in reference to the same Supreme Court resolution referenced by the defense, the Supreme Court also held there that the PNP cannot claim presumption of regularity on deaths occurring during police operations. Your Honor, I will quote that specific portion of the Notice of Resolution dated April 3, 2018, which is tab 112 for the defense at pages 47 to 48. The Supreme Court held, and I quote, the PNP cannot claim the presumption of regularity in official functions because deaths are not supposed to occur during any of their operations. The presumption of regularity in the performance of official duty must be seen in the context of an existing rule of law or statute authorizing the performance of an act or duty, or prescribing a procedure in the performance thereof. The presumption also cannot prevail over positive averments concerning violation of the constitutional rights of the accused. And Your Honor, in the next paragraph, all of it is being emphasized in the original. And I quote the emphasized portions. The Duterte administration's 2017 year-end report states that there were 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017, and 16,355 homicide cases under investigation from July 1, 2016 to September 27, 2017. This is a total of 20,322 deaths during the Duterte administration's anti-drug war from July 1, 2016 to November 2017, or an average of 39.46 deaths every day. This court wants to know why so many deaths happened, as expressly reported under the section Fighting Illegal Drugs of the Duterte administration's 2017 year-end report. Next, Your Honor. The Philippine Constitution provides for the right of life in Article 3. Therefore, because of that right to life, there is actually no presumption of regularity if a person is killed during a police operation. And actually, the presumption is reversed. It's actually the onus probandi on the police to prove that his or her actions were within the lawful requisites of self-defense. In fact, Rule 15.4 of the 2013 revised PNP operational procedures mandates the proprio motu investigations if death occurs during a police operation. However, Your Honors, despite the at least 3,967 deaths under anti-drug operations, there was no proprio motu investigations for all of these deaths. 8, Your Honor. The defense yesterday referred to the Philippine National Police Operational Procedural Manual issued in 2021. But the same was irrelevant and a non sequitur with respect to how the PNP construed and applied the word neutralize under CMC 16-2016 from July 1, 2016 until March 16, 2019, which is within the temporal jurisdiction of the court. The defense recognizes that the same Philippine National Police Operation Procedural Manual was published in 2021, specifically in September 2021. And it was already after the temporal jurisdiction of this court. Hence, it's irrelevant with respect to this case. 9th, the defense asserted that purportedly the Duterte's administration is, and I quote, intolerant for rotten apple police officers, end of quote. That's in the transcript of yesterday at page 32, line 20 to 21. This is not true, Your Honors. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for the government-recognized deaths of at least 3,967 drug personalities who died in anti-drug operations from July 1, 2016 to November 27, 2017. In fact, the undisputed fact in this case is that the Philippines only investigated at
Excuse me, counsel. You have 5 minutes left.
At most 302 cases. And I refer to the February 27, January 26, 2023 decision of this chamber on the authorization pursuant to Article 18, Paragraph 2 of the statute to resume the investigation. The court here, the chamber has held The Chamber observes that at the time of the prosecution's request, the DOJ panel had referred to the NBI for investigation and case build-up 302 cases consisting of 52 PNP IAS cases, the non-Laban cases, and 250 NPS cases. And in paragraph 39, from the information before the Chamber, it therefore appears that the DOJ panel review does not amount to relevant investigations within the meaning of Articles 17 and 18 of the statute. Moreover, the number of cases reviewed by the DOJ panel, namely 302, is very low when compared with the estimated number of killings that allegedly occurred in the context of war on drugs operations. Res ipsa loquitur. Mr. Duterte's administration has not criminally prosecuted the police officers responsible for these deaths. Last, Your Honor. The defense erred when it conflated Ms. Paulina Macida's statement that Rodrigo Duterte failed to prevent or punish with the theory that the prosecution has not charged command responsibility under Article 28. Ms. Macida's comment on the fact that Mr. Duterte did not take steps to investigate and prosecute was pronounced in the context of her submissions on the fact that encouragement of killings through public statements by Mr. Duterte sent a clear message that those responsible need not fear accountability and can act with impunity. Said comment cannot be extrapolated from that context, as the defense did yesterday. We do not suggest that Mr. Duterte should be liable under Article 28 of the statute. We maintain that there is ample evidence for confirming the mode of liability under Article 25(3)(a) as pleaded by the prosecution. Also, we want to emphasize, Your Honors, that there were indeed children murdered systematically under the charges that are being held against Mr. Duterte, Your Honor. And they are not mere collateral damage. In conclusion, the victims submit that the defense has not blemished the prosecution legal theory and evidence as provided in the document containing the charges and the pre-confirmation brief. The victims submit that the prosecution presented sufficient evidence to establish substantial grounds to believe that Mr. Rodrigo Roa Duterte committed each of the crimes charged. Consequently, all charges should be confirmed, and Mr. Rodrigo Roa Duterte committed to trial. Lastly, Your Honor. Your Honor, the victims want these charges to be confirmed because they want to be reintegrated to their communities, because they are still in the shadows of fake news, of fear and of threats from Mr. Duterte's supporters. Hence, it's important, Your Honor, that all of these charges be confirmed against Mr. Duterte so that the victims of these crimes will be taken out of the shadow of darkness into the light of truth and justice. Because in the end, Your Honors, the victims, they're also created in the image of God, and they also believe that the God of the universe is the God of justice. Madam President, Your Honors, thank you for your kind attention. This ends the presentation, the closing statement of the common legal representative for victims. May it please the Chamber.
Judge Motok. Thank you very much, Mr. Andres. We will now take our break and resume with the final submissions of the defense at 1400 hours. The hearing is suspended.
Mga kabombo at mga ka-Star Nation, yan yung naging bahagi po ng closing statement ng panig ho ng Victims Council. Itong si Attorney Gilbert Andres. Yan ho yung paglalagom niya ng mga argumento mula naman sa kanilang panig. At nabanggit ho ni Attorney Andres na sila din yung lumaban ng argumento dito sa Supreme Court of the Philippines para ho dyan sa mga usapin na nakapaloob sa issue ng mga pagkasawi, bunsod nga ng kautusan ng mga nasa gobyerno noong Duterte administration laban sa illegal na droga. Yung kampanya ho, yung tinatawag na War on Drugs campaign. Although may mga sinight ho ng mga particular issues, pero sa kanyang paglalagom ay buong kumpiyansa itong si Attorney Andres sa kanilang mga nailahad at yung bigat ng kanilang mga nakalap na testimonya na titindig pagsapit ng kung matutuloy nga itong full trial ay kanilang ilalabas ang iba pang mga impormasyon, mga kabombo at mga Kastar Nation. So mamaya i-check natin ang linya, mga kabombo, ng atin pong mga kasamahan sa bahagi po ng mga lugar na tinututukan po natin kagaya ng mga isinasagawa ho na viewing. And of course, may mga panayam pa ho tayo mamaya-maya, mga kabombo at mga Kastar Nation, hinggil pa rin dito sa usapin ng War on Drugs campaign na pinakang subject ng confirmation of charges hearing para doon sa crimes against humanity charges against the former President Rodrigo Duterte. So mga kabombo, ang mga nakahanay pa ho natin na panayam ay maya-maya na lamang at bibigyan daan ho natin ito. Pati na yung mga iba pang mga pag-uulat mula sa ating news team mula dito sa Metro Manila, pati na ho sa ibang dako ng ating bansa. And maliban ho dyan, mga kabombo, ay sinusubukan din natin na makausap sa mga oras ho na ito habang naka-break yung atin hong mga Bombo International Correspondent dyan sa The Hague, sa bahagi po ng Netherlands, upang makumusta din ho natin sila kung ano yung mga aktibidad ho nila sa mga pagkakataong ito. Lalo't ito na ho yung huling araw ng confirmation of charges hearing. Medyo mahaba-haba rin every day ay nagkukonsume ho ito ng mahabang oras mula hapon. In fact, dito sa Pilipinas, nagsisimula ho ito ng bandang pasado alas 5 at natatapos naman ho ng pasado alas 10 ng gabi. Bagay ho na magkakasunod ho na naitala mula nitong Lunes, Martes, and nilaktawan yung Miyerkules at nag-resume ng Huwebes at ngayon ho, araw ng Biyernes ay ito na yung pinaka-pinale, ika nga, mga kabombo at mga Kastar Nation. Ano't anuman ay malalaman ho ninyo sa mga pronouncement o yung mga ilalabas na mga communication ng International Criminal Court. And mamaya may recap po tayo, mga kabombo, mga Kastar Nation, ng ibang mga kaganapan mula pa nitong hapon hanggang sa mga oras ho na ito, yung mga highlights ng mga punto na nailahad mula ho sa panig ng depensa na mas nauna hong nagsalita and yung panig naman ng prosekusyon at yung tungkol ho sa mga argumento na kanilang nailahad, pati na hanggang dun sa bahagi po na naging paglalagom ni Attorney Gilbert Andres ng Center Law at isa sa mga accredited lawyers ng International Criminal Court, mga kabombo. And siguro sa mga susunod na araw ay susubukan din ho natin na makausap ng personal itong si Attorney Gilbert Andres para siya mismo yung makapagkwento kung ano ho yung takbo ng kanilang mga aktibidad ho dyan, pati na yung sitwasyon ng mga paghahanda. No? At ganun din, kukuha din ho tayo mula sa panig ng depensa and we're trying to connect with Filipino lawyers kagaya ho ni na former Labor Secretary Silvestre Bebot-Bello III at ganoon din si Attorney Salvador Salpanelo, mga kabombo, mga Kastar Nation, na nandun at nakita ho natin sa ilang pagkakataon na kasama ho dyan sa mga aktibidad ng panig ho ng depensa, mga kabombo. In fact, nagkaroon pa ho ng meeting itong si Nicholas Kaufman at yung mga Filipino lawyers na mga former cabinet officials ni dating Pangulong Rodrigo Duterte. Sa isang pagkakataon ho ay nagsama-sama ho sila na nagpulong dyan sa bahagi po ng Netherlands, mga kabombo. oras natin sa buong kapuluan, meron na ho tayong 6 na minuto makalipas ang ikawalo ng gabi at nakaantabay pa rin ho tayo sa iba pang mga development hinggil ho dito sa ating binabantayang kaganapan. And mamaya pa ho, magre-resume muli itong confirmation of charges hearing. So tutok lamang mga kabombo, mga ka-Star Nation sa atin hong palatuntunan at ang ating special coverage. Meantime, unload muna ng mga commercials yung atin hong mga kabombo at mga ka-Star Nation dyan ho sa mga himpilan ng Bombo Radio Philippines. Tutok lamang at magre-resume pa rin. Tututok pa rin tayo at pag-aantabay sa mga kaganapan sa dahig sa pagpapatuloy ng confirmation of charges hearing sa the Netherlands. International Criminal Court mga kabombo kung saan nahaharap na sa crimes against humanity charges ito si former President Rodrigo Duterte. Mamaya ay magbabalik ho tayo. Makalipas lamang ang mga paalala.
For the most trusted source of news and information, visit our website at www.bomboradio.com. Follow us on Bombo Radio mobile app, Facebook, YouTube, TikTok, and X, formerly Twitter. Like, share, and stay connected. Anytime, anywhere.